Good morning, everyone. Good morning. We're going to ask that everyone please move to your seats so that we can proceed with the next panel. Good morning, everyone. If you could please kindly move to your seats, we're going to move forward with the next panel. Good morning and welcome back from the break. I am Lieutenant Commander Chris Hart. I am a submarine officer and assistant professor of law here at the Naval Academy's Leadership, Ethics, and Law Department. I'm excited to be here to hear our panelists speak about a very important issue in the law of war, which is the role of military manuals in developing and understanding the law of war, with a special focus on the U.S. Department of Defense Law of War Manual. Our panelists today are Professor Laurie Blank, who is a clinical professor of law and a director of the International Humanitarian Law Clinic at Emory University School of Law, where she teaches the law of armed conflict and works directly with students to provide assistance to international tribunals, non-governmental organizations, and militaries around the world on the cutting-edge issues in humanitarian law and human rights. During the 2022 to 2024 academic years, she served as special counsel to the General Counsel at the U.S. Department of Defense. And Mr. Karl Chang is an Associate General Counsel in International Affairs in the Department of Defense Office of General Counsel. Since 2006, he has worked as a lawyer at the Department of Defense on a variety of national security and international law issues, including in the areas of jus ad bellum, international humanitarian law, and international law on the exercise of jurisdiction and immunities. Importantly for today's panel, he is also the principal drafter of the Department of Defense Law of War Manual and the 2020 DoD Directive on the Department of Defense Law of War program. So thank you for joining us today, and with that I'll invite Mr. Chang up for his remarks.
Good morning. Thanks for the introduction, and thanks to colleagues for the warm welcome and the opportunity to talk here today. So before I dive into my remarks, I'll just say a couple words about my day job in DoD ODC. So the General Counsel is the Secretary of Defense's lawyer, and staff in ODC help support the General Counsel in providing advice to the Secretary. We also advise the Secretary's staff, the Assistant Secretaries, Undersecretaries, Deputy Assistant Secretaries, and so forth. The General Counsel's office also leads DoD efforts to implement the law of war, things like the Law of War Manual and Law of War program I'll talk about today. And then we also advocate for the department and engage internationally on law of war issues, working closely with our colleagues at the State Department. So today I'd like to, let me find the clicker. So you can see this is a very well-rehearsed presentation. I'm going to try this. Let's see. So first I'll talk a little bit about the Law of War Manual and Law of War program, and then I'll try and expand today on a number of aspects of the law of war that, in my opinion, are important to the practice of law of war at DoD and reflect the DoD's take on the law of war, which may be different from the take of academics or NGOs, ICRC, others. So I'll first start with just the very boring DoD policies, DoD Directive 2311. It's the DoD Law of War program. And this is the policy that establishes overarching DoD policy to comply with the law of war in military operations. It also defines roles and responsibilities, like the responsibility of General Counsel for helping to administer the program. The key elements of the law of war program are noted right here. So there's an overarching program, and then each of the components do have these specific elements as well, and it'll be things like dissemination and training, so promulgating the Law of War Manual and issuing service publications on the Law of War, as well as training personnel. There's legal advisors, so for example, staff judge advocates who advise commanders. A number of regulations and procedures are also relevant, such as our detention policies or regulations, ROE, other kinds of doctrine like targeting doctrine can also be important for law of war implementation. There's reporting procedures. This is outlined in DoD Directive 2311. So that's a reporting requirement. If there's a potential law of war violation, it's to be reported through the chain of command to the commander who reports to the chairman and the secretary. There's also investigations of incidents and then corrective actions. And corrective actions can include criminal prosecutions and punishment, but it can also include an array of non-criminal actions, non-judicial punishment, training, policy changes, and other kinds of reforms to SOPs to help improve and reduce the likelihood of future violations. So within that framework of the Law of War program, we have the DoD Law of War Manual. And so the Law of War Manual was preceded by a number of service manuals. Navy, Air Force, Army, Marine Corps have had a number of publications on law of war. This is the first joint all services publication, and the history of these manuals is discussed in the preface to the DoD Law of War Manual. So the manual was first published in June 2015, and it's been updated 3 times, May and December of 2016, and then July of 2023. I will also confess to having the wrong picture here. So I used an old slide deck, and I should update the cover with the one that says July 2023. The manual is prepared by the DoD Law of War Working Group. So that's a group with representatives from the Army, Navy, Air Force, Marine Corps, their international law, national security law offices, as well as a representative of the Office of the Legal Counsel of the Chairman of the Joint Chiefs of Staff. So the working group would prepare these drafts, and then we would consult with the Department of State and the Department of Justice before issuing the manual, and then it would formally be issued by the DoD General Counsel. Under the directive, under DoD Directive 2311, Law of War Manual serves as the authoritative statement on the law of war within the Department of Defense. And basically, it's doing a couple of functions. One, it's disseminating the law of war rules. So in a relatively brief DoD directive, we can't include all the pertinent law of war rules. The Law of War Manual is an effort to include all the rules. It also tries to clarify ambiguities and provide explanation and practical examples for people in applying the rules. And a third purpose is to enable a common understanding within the department on the law of war for all the purposes I've noted. Pardon me. Of training, advising on the law. Maybe a last point I would make, an ancillary purpose of the manual is to help communicate DoD views to counterparts in foreign countries. It can assist a lot in coalition, multinational operations, where people are trying to compare and develop common understandings, for the purpose of facilitating joint operations. The manual is really written for lawyers to reflect the practice of law within the U.S. government, within DoD, and the intent is to provide a resource for practitioners, in particular judge advocates, to help them advise commanders, train, conduct legal reviews of weapons and plans, et cetera, to perform all the activities I've described under the Law of War program. So the intent is to be very focused on the practitioner and helping the practitioner with a resource. I think the other very thematic point I would offer is it's like a manual, it's an encyclopedia, it's a reference work. The hope is to be as clear as possible, to have the thing speak for itself and not require me or somebody else to come in and tell you what it means. So that's the general intent. I did also want to note the General Counsel's memo of August 2020, which provides a brief overview of the law of war for DoD personnel, and that's written at a much more manageable 12 pages, and it's useful as a reference work also for non-lawyers, kind of a nutshell introductory document. So that's just a little bit about Law of War Manual and Law of War Program in general. Just wanted to give people a sense of bureaucratically, administratively, how these things are figuring in. Now I'd like to talk a little bit about how I think the department's understanding of the Law of War may differ from other academics or NGOs and that kind of thing. And I think it's three general themes that I've noted on this slide. First, the law of war reflects a convergence of military and humanitarian interests. Second, that the law of war both justifies and restrains military action. And then third point, the law of war lives in the character of the armed forces and their daily work preparing for and fighting war. So those are the three themes I would like to hit next. So I really want everyone to try and read all this very small text on the slide. Actually, the main point I want to make is about the law of war principles of necessity and humanity. And there's an often taught view that the law of war reflects a balance between the principles of military necessity and humanity. I've picked on the International Committee of the Red Cross, a very esteemed organization, and it says IHL is a compromise between two underlying principles of humanity and of military necessity, and this shapes all the rules. Taken to extreme, this view is captured in the metaphor that is sometimes used that complying with the law of war is like fighting with one hand tied behind your back. And fundamentally, I think DoD does not share this particular perspective on the law of war. And I'll just use the articulations of necessity and humanity in the Law of War Manual to illustrate the point. Section 2.2 explains that military necessity is a principle that justifies the use of all measures needed to defeat the enemy as quickly and efficiently as possible that are not prohibited by the law of war. And 2.3, humanity is the principle that forbids the infliction of suffering, injury, or destruction unnecessary to accomplish a legitimate military purpose. So the manual explains, because humanity forbids those actions that are unnecessary, the principle of humanity is not in tension with military effectiveness, but instead reinforces military effectiveness. So from the department's perspective, humanity and necessity are fundamentally consistent with one another. They're opposite sides of the same coin rather than principles in tension with one another. Law of war is not about fighting with one hand tied behind your back. That's a stupid way of fighting. Fight with both hands, win as quickly as possible, but don't kick your opponent after the fight is over, just to be cruel. So that's one point. The second point I wanted to make was about the law of war both justifying and restraining military action. Now, the part of the law of war that is most apparent and discussed is its protective, its humanitarian aspect, how it restrains the armed forces in the conduct of hostilities. This is absolutely important and a critical part of the law. It protects civilians, it protects fighters who are hors de combat, it protects the wounded and sick and medical personnel. But I believe the law in practice also performs another function. It serves not only as a shield to protect the defenseless, but it also serves to justify military action. And this is Justice Jackson's formulation of this point, as he's tasked to lead the prosecution of Axis war criminals after World War II. This is a statement that comes from one of his reports on the Nuremberg trials. In his words, international law throws a mantle of protection around acts which would otherwise be crimes when committed in pursuit of legitimate warfare. In this, they are distinguished from the same acts in the pursuit of piracy or brigandage. Brigandage is a fun, archaic term for what we would call terrorism today. And of course, you've all heard the cliche that one man's terrorist is another man's freedom fighter, but this is antithetical to the laws of war, right? One of the key purposes of the laws of war is to distinguish between the privileged combatants, like members of the armed forces, and terrorists. The law of war justifies the member of the armed forces killing of enemy combatants in war. It's not murder, it is an act of privileged belligerency. So here's a fun historical example, the Emancipation Proclamation. The Emancipation Proclamation justified the emancipation of slaves during the Civil War in the rebellious states as warranted by the Constitution upon military necessity. So President Lincoln frees the slaves in enemy territory, the Confederacy, and he received a lot of criticism of the action at the time as an illegal action. Right? People said it was an unconstitutional taking of property without due process of law and just compensation. President Lincoln answered his critics with a letter that was published widely. The Constitution invests its commander-in-chief with the law of war in time of war. Now, he's saying that if we can do something that's justified on the principle of military necessity and consistent with the laws of war, it's consistent with the Constitution. And I love this example because it's a historical example, but it's an example that comes from a struggle for the soul of our country, and the law of war is helping us do the right thing. Okay, ex parte queer. This is a fun Supreme Court case. It involved German saboteurs who landed on Long Island. They were tried by a military commission and set up in the Department of Justice. Another fun fact about this is that the defense counsel for these German saboteurs was a gentleman named Kenneth Royal, who later goes on to become the last Secretary of War and the first Secretary of the Army. So Royal, as defense counsel, argued that the president couldn't try his clients by a military commission because the Constitution required trial by civilian courts and protections in civilian courts that weren't granted in military commission. And the Supreme Court rejected this argument, finding that the saboteurs are enemy belligerents who are subject to law of war and can be tried by military commission. Here's a third example, more contemporary, Hamdi versus Rumsfeld. Mr. Hamdi is a Taliban fighter who was detained and captured and detained after U.S. military operations in Afghanistan. He happens to be a U.S. citizen. So he files a habeas petition, and the Supreme Court rejects the argument that he's being held unlawfully in violation of the Constitution and a provision of law called the Non-Detention Act, and instead finds his detention was authorized by a statute, a very general statute authorizing use of military force as a fundamental incident of waging war. And in particular, the Supreme Court cites law of war rules in the Geneva Conventions in upholding the legality of his detention. So the basic theme underlying these cases that I wanted to stress is that an action may be unlawful in peacetime. However, during war, we look to the law of war, and if the action comports with the law of war, there's an argument that it's lawful despite the ordinary peacetime rule. And that's, I think, the very basic principle that's going on in these cases. And I think it illustrates an important point about the law of war in practice, that it has a protective function, that's very true and important, and the core part of it, but it also has a legitimizing and justifying function. And it justifies, namely, killing and destruction, seizure of persons and property without the due process that's normally afforded. So here on my next slide, I'm picking on Karl von Clausewitz, brilliant celebrated military theorist, and he has a fun line about the law of war, and when he's trying to define war. Attached to force are certain self-imposed, imperceptible limitations hardly worth mentioning, known as international law and custom, but they scarcely weaken it. So times have changed a lot since the 19th century. When Clausewitz was writing, I think he might take a different view today. But I use this slide because I think it's important to engage with skeptics of the law of war, to people who are kind of truly skeptical about whether this is a real thing or not. And I do believe it's a real thing. Part of it is the program of implementation that I described in the DoD Law of War program, which is reflected in the daily work of a lot of judge advocates, military and civilian lawyers throughout the department. But the main point I want to make is that the law of war lives in the professional ethos of the armed forces and in their daily work preparing for and fighting war. Now, most scholars approach the law of war from the perspective of treaty text. We'll find the treaty or the instrument where the law is, and that's where we find the law. Often academics will interpret the law of war using war crimes trials, because these are cases and judicial opinions are things that lawyers are quite familiar with. These are part of the law, in my view, but they're only the smallest part. If you use these as your principal frame of reference for understanding the law, of war, then I believe you won't have a proper understanding of the law and how it's implemented. And so this is where the DoD Law of War Manual really does emphasize the principle of honor as a fundamental principle of law of war. And again, this is an area where we differ some from other academics or NGO kinds of treatments, which don't list honor as a fundamental law of war principle. For us, it is. And oops, I think I've got that one. Okay. And I would use John Keegan's words when he was talking about this point. He says, "There's no substitute for honor as a medium for enforcing decency on the battlefield. Never has been and never will be. There are no judges, more to the point, no policemen, at the place where death is done in combat. That may be, in fact, the intended and all too often true meaning of silent legis inter arma. All terms and the values of the junior leader present at the moment when the opponent's capacity or will to resist fails, he ceases to be a combatant, and he must suddenly hope for the mercy of the suddenly stronger." And here I've got up on the slide, Mr. Thompson, Chief Warrant Officer Thompson, and when asked to explain, why he did what he did in stopping the My Lai massacre, he didn't turn to his law of war training, but he just talked about his values. And so I do believe this illustrates a very important point that on the battlefield, people comply with the law of war, not because of fear of prosecution or some of the other mechanisms of law, but because they've internalized it, because it reflects their values and characters, because it's part of who they are. The other point I wanted to make was, again, drawing on Justice Jackson, and to borrow his points about moral suasion as one of the forces that implements the law of war. The point he was trying to make is that everybody thought that Germany would be militarily powerful and successful and would in fact win the war. But I do love his point when talking to skeptics like Clausewitz. We may go forward on the assumption that reason has power to summon force to its support, confident that acceptable moral standards embodied in law for the governance of nations will so appeal to the better natures of men that they will ultimately vouchsafe the force to make them prevail. And I don't think we should overstate the amount of divisions the Pope has, but I do think this is a very powerful force that shouldn't be underestimated, that in some sense right can help lend power to might. And I think one example of this is the strikes that were taken in response to Syrian chemical weapons facilities in 2018. Maybe just last to close, I'm probably at time or a little bit over. I would just end with two very general reflections on the law of war and ethics. First, the point I'm trying to make is that law of war depends on ethics as a medium for its implementation. And so I think that's a critical way that the law depends on ethics. In some ways, I think this principle also can cut the other way, that we don't like rules that don't comport with our views on military necessity and humanity, that don't comport with our practice, that don't comport with our ethics. And for me, it's telling that every single law of war treaty that has gone up to the U.S. Senate for advice and consent to U.S. ratification has always been accompanied by a robust explanation saying that these are things and values and practices that we already do, and they're already part of who we are. So I do think there's a strong connection between law of war and ethics, and that ethics is a vital medium for its implementation in the U.S. Armed Forces. And the second point I wanted to make is that law gives legitimacy and it justifies killing in war. And I think this is a very powerful thing that law is doing for ethics, doing for the ethics of war. And then I also think there's a flip side, right? If compliance with the law provides a moral power, then violating the law also evinces a kind of moral weakness. And this is the the point that I think Justice Jackson is making about Germany, and a point which shouldn't be overstated, but I think is relevant, continues to be relevant today. So with that, I thank you for your attention and appreciate the opportunity to share these perspectives.
I'm going to try to stay warm enough without my blanket in this room. Thanks very much for having me. It's really a privilege to be back here at the Academy and on such a beautiful day. So, following on some of Karl's discussion and reference to the Law of War Manual, in November of 2016, the DoD General Counsel at the time, Jennifer O'Connor, explained that for the manual to achieve its purpose, it has to be a living document, right? Meaning it has to not just be static, and obviously provide as much clarity on these very tough issues on which lawyers must advise. So thinking about it as a living document, I thought it would be interesting to think about some of the some interesting questions that the manual has raised, produced some debates. Looking forward, right, thinking about some of the current and forward-thinking issues that arise in the law of war, particularly with respect to emerging technologies like cyber, maybe not emerging, present, newish, recent technologies like cyber, artificial intelligence, space operations, autonomous weapons, and so on. Assessing and advising how the law of war applies in those contexts presents a host of interesting questions, ones that are not new to the law of war, but may present, sort of require a rethink, reconsideration. And those are, again, very basic questions in the law of war, but they become sort of interesting and new in these contexts. So who or what is a legitimate target? Sort of the fundamental question that the law of war needs to answer and that lawyers advise on during military operations. Understanding civilian harm, what it is, the extent, when it is acceptable, when it is excessive, and what precautions are feasible and therefore required in the context of mitigating civilian harm and minimizing the risk to civilians. So these questions and sort of these new and emerging domains and technologies offer an interesting lens to consider some of the debates and hard questions that have arisen with respect to the manual over the last, I guess it's now almost 10 years, which I guess it's time to have a 10-year anniversary event on the Law of War Manual. Many of these debates ultimately center around two questions. Who is the person, or what is the object, but more specifically, who is the person, meaning what is the person's status, this person who may be a lawful target, who may be attacked, potentially could be detained, but generally thinking more in the context of the use of force. What is this person's status under the law of war? And what is the nature of the relevant activity this person is or potentially might be involved in, which then would implicate their protections, sort of building on what their status is, right? Is the person a lawful target? Is the person protected from attack? When? Is the person protected by the rules of proportionality and precautions? Does the activity in question change the person's status, change the person's protections? What kind of harm to this person or the person's surroundings need to be taken into account in making decisions about the use of force? When we move away from the physical, tangible, terrestrial environment, where we have our feet on the ground and where we can touch things and see things, and into domains where we can't see what is going on, like space. I mean, a few who have, right, the capabilities, et cetera, can, quote, see what is going on, but generally we all can't. Or into the use of capabilities where we have less sense of how decisions are made. It can be a lot harder to understand how these different questions and issues play out, and harder to determine how the law should be applied or how it is applied. So for example, let me throw out some examples. Consider cyber. Think about activities like writing and executing malicious code, launching DDoS attacks, providing malware or other cyber tools to a party to the conflict, building a botnet for use against the adversary. Are these things direct participation in hostilities? Do these activities make somebody a member of some non-state group, of a cyber organized armed group, if there is such a thing? What about individuals who engage in cyber operations that do not qualify as attacks as defined by the law of war, but nonetheless contribute to cyber attacks? Hacking into an enemy computer to gather information that would be used in launching an attack. Planting a worm in the software that breaks down defenses, enabling a subsequent attack to be successful. Right? These just add texture to the ongoing discussions about, for example, what is direct participation in hostilities? What does for such time mean in cyber? Right? The law says that a civilian is protected from attack unless and for such time as he or she is directly participating in hostilities. There's a general understanding that acts preparatory to that direct participation act or returning from engaging in that direct participation act are considered part of that overall direct participation. But what is an act preparatory to pushing a button on your keyboard, if that's what sort of launches the cyber? Again, I'm going to use attack in quotes because attack gets used lots of ways colloquially and in the law. Right, these are all interesting questions that come up with respect to cyber. If we consider space, right, some other interesting questions that flag some of these issues that we then see debates about the Law of War Manual. What is civilian harm? The rule of proportionality says that parties to a conflict must refrain from attacks in which the expected incidental harm to civilians, so harm you don't mean to cause, but you expect may result. The expected incidental harm to civilians, if it's excessive in relation to the anticipated military advantage gained, you cannot launch that attack, right? That is designed to enhance protections for civilians and minimize the harm that they suffer in the course of combat operations. Well, when we think about space, one question that comes to mind for me is which civilians, right? I think our common understanding of proportionality is if you imagine a conflict between two groups, maybe two states, or a government and an armed group within that state, or multiple armed groups, we have a geographical conception of where those civilians are. They are where the fighting is happening. But when we think about space and its integration into military operations, space objects that might be the lawful target of attack during an armed conflict provide services to people all over the world. And attacks, if we're thinking about the incidental harm that might happen to civilians, do we need to think about civilians who might be 10,000 miles away, right? A satellite might include on its one of its payloads could be, for example, some kind of early warning system for weather events far, far away from where the conflict is, or emergency services, or so on. So do we need to think about broadening our conception of civilians in that context? Another one is reverberating effects, right? Very challenging and frequent issue for debate. What is the extent of the harm? How far out from the immediate effects of an attack do we consider the harm to civilians? And this obviously is it's a very hard issue on the ground. particularly in urban settings, and it looks different and perhaps almost unanswerable in the space context. Think about space debris, right? An attack on a object in space that is a lawful military objective could produce space debris. If you've ever seen any of these models for how debris in space first happens and then continues, right? It just keeps breaking up, and you can see these models where you just see it orbiting, and it's not clear. It's not like I imagine there will be the technology at some point to try to clear it out in some way, but it's not quite the same way as trying to deal with the effects of an attack on sort of terra firma, for lack of a better term. And so how do you assess that damage? Does every commander need to have space modeling available to him or her? What about autonomous weapons? And lots of debates, and Karl, is one of the lead folks thinking about this at DoD, about how to implement core principles of the law of war and obligations in the development and use and deployment of weapons that have some type of autonomous capabilities. Here we can think about the reasonableness, which is a core touchstone of the law of war. We think about the reasonable commander. So much of the law of war and assessing how to make decisions, how to apply the law, involves reference to concepts of reasonableness. How do you take reasonableness and put it into a machine? How do humans think about reasonableness in the context of a machine? However much that machine learns, however much it is a nimble and agile actor, it is still, from our perspective, a machine. I don't tend to think about whether my toaster toasted reasonably. I don't tend to think about whether my calculator was reasonable when I type in a bunch of numbers and I expect the exact same answer and the right answer every time. I'm not really considering that if it got close, well, it was a tough day. I used it a lot yesterday, so it's reasonable that it was a few digits off. I was that way when I used to try to balance my checkbook, but that's why I don't do that by hand anymore. So we see some of these questions coming up really from a different angle, right? Because I think for me, when I participate in conversations about autonomous weapons, when I watch the debates, when I read about the debates, I think that underlying some of this is just a drive to understand what these weapon systems are, how they work, and how humans would interact with them, right? That's sort of a fundamental underlying issue. And what is that about? That's about certainty, which is very much not the same as reasonableness, right? The law of war has tolerance for disparate judgments. We don't really envision that for machines. And so we can see a lot of questions about certainty when we think about autonomous weapons. I would categorize these in three ways. The certainty of technology. How does this darn thing actually work? What are its capabilities? What are the extent of them? Is it durable? Will it break? Is it reliable? Is it going to do the same thing every time? What might make it do something wrong or different? Another category of certainty would be the certainty of legal norms, right? What exactly is the content and meaning of the relevant legal norms? When we have multilateral discussions, let alone discussions where you bring in academics and NGOs and others, but even just in multilateral discussions on the law of war, there is not one single voice and one single shared conception of what every single principle and treaty provision means, right? There are debates, and not all states are parties to the same treaties, and not all of them interpret them the same way. What's the one that the autonomous weapon is supposed to be applying in that sense? So that's another issue of certainty. And then, of course, certainty of analysis and decision-making. How does it make decisions? Will it make the same one every time? What level of certainty or flip side doubt, should, just the same way we have a question for a human being, we have to think about for a machine actor. What level of certainty or lack thereof is appropriate with respect to identifying a target, civilian harm, and so on. We instinctively have a comfort level with human judgment and human decisions, because that's the kind of decisions and judgment that we understand in our own brains, even if some of us do it not always at our best all the time. But we certainly don't have the ability in that sense to relate to a different kind of actor. So with just thinking about those, how some of these questions arise in this sort of current and forward-looking space, I thought I would just offer a few examples of how some of these issues or companion issues have arisen in debates about the manual, and how they have been addressed in some way. And I think part of this, for me, I think what's valuable in thinking about these questions is thinking about how rich the conversations are about the law of war. Obviously the most important thing is that the law is available to military personnel and all other actors in armed conflict as a tool, as a guidepost, as both our first speaker has talked about, our first panel, and Karl, right? It's a critically important tool. It is there also, obviously, to protect those who are vulnerable during armed conflict. But it's also really important that it is robust and that there are robust discussions about it. That's what makes it work, is that when we are engaged in thinking about some of these hard questions. So let me just throw out some for purposes of just illustration. So one that obviously led to the most recent update to the manual was this question of what's called presumption of civilian status. Under the law, in the most basic framing of how the law thinks about persons, persons are either combatants, if it's international armed conflict. If it's non-international armed conflict, we might call them fighters or members of an organized armed group. They're either people whose job is to fight, again, that's not a legal definition, but sort of descriptively, or they're civilians. It's not quite that easy because there's sort of lots of interesting questions about when somebody qualifies for combatant status or when they're a member of an organized armed group. But the concept that you're either a combatant/fighter or a civilian is critical. It's essential to the implementation of the law, to accountability and enforcement, to training, and everything. So because it's not entirely clear how those definitions always apply and where someone falls, it's not just the definition that matters, but it's the process of making that determination and that identification that is critical. And so the debate about this concept, presumption of civilian status, was ultimately about what to do when there is doubt, right? If I see any of you in uniform on the battlefield, I know you are a member of the armed forces. But I might see people whose appearance, whose activity, and anything else I can, extract about them leaves me with questions. And so I would need to be able to make that assessment. One treaty, Additional Protocol 1, which the U.S. is not party to, says that in case of doubt, whether a person is a civilian, that person shall be considered to be a civilian. Obviously, the U.S. is not a party to this treaty, so this provision does not apply as a matter of treaty law to the United States. Earlier versions of the manual stated that under customary international law, no legal presumption of civilian status exists for persons or objects. This statement produced extensive debate about, as a matter of law, whether the law does require that persons be considered to be civilians when there is doubt, because remember, customary law is binding on all states. It also provoked a debate about whether the U.S. actually was presuming that persons are fighters or combatants when they had any doubt. Two different debates. What is practice? What is considered to be the legal obligation? In 2023, the manual was updated to address this issue and the debate, and now states that under the principle of distinction, commanders and other decision makers must presume that persons or objects are protected from being made the object of attack unless the information available at the time indicates that the persons or objects are military objectives. This presumption is the starting point for the commander or other decision makers' good faith exercise of military judgment based on information available at the time. It then includes a lengthy discussion about the process of identifying and classifying persons, because it's not just your initial starting point. It's like you have to actually reach a determination so that you can determine what your course of action is. And so the section focuses on good faith, that this determination must be made in the honest and genuine belief that a person or object is a military objective and cannot be based on speculation. It must be based on available information. Obviously cannot close your eyes and say, oh, gee, I just don't know anything. I don't see anything. But also can't be hampered by essentially, let's call it paralysis analysis, where you could always hope someday that you might have some additional nugget of information. And based on feasible precautions to verify that, in fact, that person is a lawful target. What this is fundamentally about is the idea that the law allows for incomplete information or doubt, does not require absolute certainty. So a party to a conflict can consider a person or object to be a lawful target even if there is some doubt, as long as the decision is made in good faith based on information available at the time and taking feasible precautions. And what I think is so important about the sort of debate that went on over this issue, the process that went on in updating the manual and the updated version, is it really gets at a core feature of the law of armed conflict, which is that the law is not just about rules and obligations and principles. It's very much about a methodology to apply those rules and to implement those rules, right? And so, for example, proportionality and precautions are not just rules that say, here's how you protect civilians. They are very much a process for how you think about targeting in a way that enables both the application of deadly combat force against a lawful target and the minimization of harm to civilians at the same time, right? And so this debate and this process and this update to the manual is sort of a small encapsulation of that process. I didn't keep track of time. Tell me how I'm doing.
You're doing great. We are going to go till 12:25, so we'll leave a couple
There's a clock. Okay, sorry. I had no way of telling what was going on. Let me throw out another example, which is coming back to this concept of proportionality. Some key questions that come up with proportionality are what kind of harm is included, right? And which civilians are protected, and what about others who are not civilians but also enjoy protection under the law of war? Are they protected by proportionality? And so one place this has come up is in this idea of reverberating effects that I mentioned with respect to space. So the law says, when it talks about civilian harm, it references civilian death, civilian injury, or damage to civilian property. That's the category of harm that must be taken into account in assessing proportionality. There have been a lot of interesting discussions over the last several years about what types of harm fall into this category. For example, does mental harm, trauma, etc., fall into this category. I think there's a general consensus that that does not minimize the importance of mental harm and trauma, but as an understanding of treaty law, at least as of now, that seems to be the general consensus. But what about the reverberating effects or indirect effects that may result sometime after the attack or farther removed from the area where the attack is? Consider, for example, an attack on a power grid that is supplying power to the armed forces. It's a lawful target, but it also supplies power to civilian facilities, perhaps to a hospital. And when that hospital doesn't have power, there are going to be people whose lives depend on the machines in the hospital that are helping them breathe, and so on and so forth. And so are those the harms, the deaths caused or other harms caused, considered in terms of the proportionality? What about attacks that may result in harm to or hampered operation of water treatment facilities, and then there is untreated water, and then there is disease, and that may not arise for months or even potentially longer afterwards? Do these types of harms have to be taken into account? When? To what extent, right? Should this be based on foreseeability? Should it be based on temporal proximity, geographic proximity, or distance? And those are also hard questions. The manual generally talks about direct harms, but incorporates some examples, I think, that show not a very narrow conception of what is direct harm. And many of our allies and partners' military manuals assert that long-term effects must be taken into account if they are reasonably foreseeable. Of course, we could have a whole separate conversation for probably a few days about when effects are reasonably foreseeable, what that means, and so on. But at least this seems to be a gathering point. And so we see a host of questions. I'll just toss out two others without getting into any discussion. But there's been a lot of discussion, for example, about military medical personnel, wounded and sick. These are categories of persons who are protected during armed conflict. But they're not included in that concept of civilian death, injury, or damage to civilian objects that we see in the proportionality rule. So if we're assessing proportionality, do we have to include harm to military medical personnel? Do we have to include harm to wounded and sick on the battlefield? That has provoked some interesting discussion. The manual says that proportionality generally does not require consideration of military personnel and objects, even if they may not be made the object of attack, because they are not civilians. And we can see the challenge here, right? Because protection of the wounded and sick and military personnel, medical personnel, is at the original sort of foundation of the modern law of war treaty system, right? That's the first Geneva Convention of 1864. Those of you who have sort of studied some of the history of the law of war be familiar with the Battle of Solferino and Henri Dunant and how the ICRC was founded and the Geneva Conventions and so on. And so concern about harm, collateral harm to the wounded and sick and to those who are treating them is very consistent with the humanitarian purposes of the law, but not consistent with the language of the treaty. And it's operationally very difficult to see how that would work, right? Imagine you fire a first salvo of artillery at an enemy unit. You don't just fire one and be like, oh, that was good. It's, you're going to have multiple rounds of artillery. Do you have to stop after each one and consider exactly how many enemy personnel were wounded and where they are and so on. It seems unworkable operationally. The manual, I think, takes a very tidy approach to this, which is to say that precautions and taking feasible precautions to reduce the risk of harm is a suitable way to approach this. I'm going to leave it there since I think we're closing in on time, and thank you very much.
Well, thank you both so much for those fascinating remarks. We do have actually 10 minutes. We're going to go until 12:35 for questions. So I invite anybody who has a question to please proceed to a microphone. And sir, the floor is yours, please.
Dr. Black, since you mentioned hospitals, it kind of strikes a nerve.